Good afternoon, everyone. I am Attorney Julito Doria, Acting Chief of the Prosecution and Litigation Division, Legal Service, and at the same time, the Chairman of the Review Team under the Project Management Office. Today, I will discuss the salient points of Customs Administrative Order 1-2020, also known as Fines and Surcharges for clerical errors, misdeclaration, misclassification, and undervaluation. This administrative order implements the following provisions of the Customs Modernization and Tariff Act. Section 108, which provides for the penalties for inadvertent errors, and Section 1400, which covers misdeclaration, misclassification, undervaluation in goods declaration. So, the coverage of this CAW includes all goods declaration for exportation or importation, and whether for consumption, warehousing, or admission. The main objective of this policy is to ensure that goods are properly declared in accordance with the procedure and deter commission of small and inadvertent mistakes. In this way, the declarant will be more attentive and vigilant in the lodgement of goods declaration. Significantly, the general provisions of CAW 1-2020 covers these three broad subjects, namely fines for clerical error, imposition of 250% surcharge, and the imposition of 500% surcharge. First, we will discuss fines for clerical error in goods declaration. Under Section 4.1 of this CAW, a fine of 5,000 pesos shall be imposed by the collection district for every clerical error determined to have been committed in the covering goods declaration upon lodgement thereof. For purposes of the imposition of fine, an error is considered clerical when the same is inadvertent, provided that it is not attendant with fraud and not due to gross negligence. Relatively, inadvertent error refers to a mechanical, electronic, or clerical error committed unintentionally by the declarant, which occurred notwithstanding the maintenance of internal controls necessary to avoid such errors. This may include misspelling, incorrect input of data while drafting, copying, or transposing a document. The error contemplated is committed when there is an incorrect or erroneous input of data on the following: A. Consignee's name, importing vessel or aircraft, port of departure, port of destination and date of arrival, number and or marks of packages, the quantity, the nature, and correct commodity description of the goods contained therein, value as set forth in the invoice and packing list, and such other information as may be required by rules and regulation. Under Section 107 of the CMTA, the declarant shall be responsible for the accuracy of the goods declaration. Thus, the declarant should be careful in accomplishing the goods declaration to avoid the imposition of fine. It should also be noted that under Section 4.2, the 5,000 peso fine shall be without prejudice to the imposition of additional fines or penalties for other inadvertent errors discovered in the goods declaration. Now we now go to the imposition of 250% surcharge. Under section 4.2, the 250% surcharge, in addition to the assessed duties, taxes, fees, and other charges, shall be imposed when the following are present. A. Where the resulting discrepancy in duties and taxes to be paid between what is legally determined upon assessment and what is declared arose from misdeclaration, misclassification, or undervaluation. And when the discrepancy in duty and taxes to be paid between what is legally determined upon assessment by the port and what is declared amounts to 10% or more. The surcharge equivalent to 250% of the duties and taxes shall be imposed in the following instances. As I have mentioned earlier, misdeclaration, undervaluation, and misclassification. Insofar as misdeclaration is concerned, it refers to the quantity of goods, the quality of goods, description of goods, the weight of goods, measurement of goods. Thus, it is imperative to define these terms so we could better understand the implications of its commission. First, what is misdeclaration? It refers to a false, untruthful, erroneous, or inaccurate declaration as to quantity, quality, description, weight, or measurement of the goods, resulting in deficiency between that duty and tax that should have been paid and the duty and tax actually paid. On the other hand, misclassification refers to the use of insufficient or wrong description of the goods, or the use of erroneous tariff headings and subheadings, resulting in this deficiency between the tax and duty that should have been paid and the duty and tax actually paid. Undervaluation, on the other hand, refers to a situation when the declared value fails to disclose in full the price actually paid or payable, or any dutiable adjustment to the price actually paid or payable, or when an incorrect valuation method is used, or the valuation rules are not properly observed, resulting in a discrepancy in duty and tax to be paid between what is legally determined as correct value against the declared value. Lastly, we discussed the imposition of the 500% surcharge. A surcharge shall be imposed equivalent to 500% of the duties and taxes due when the misdeclaration, misclassification, or undervaluation is intentional or fraudulent. The imposition of the surcharge shall be in addition to the seizure of the subject shipment. How do we determine if the misdeclaration, misclassification, or undervaluation is considered intentional or fraudulent? It is when a false or altered document is submitted, false statements or information are knowingly made, or other similar instances. Additionally, Section 6 of this order discusses the principles of prima facie evidence of fraud. It is stated that in case of misdeclaration, misclassification, or undervaluation, a discrepancy amounting to more than 30% of the duty and tax to be paid between what is legally determined and what is declared shall constitute a prima facie evidence of fraud. For example, if the declared duties and taxes is 10,000 pesos, but after due examination of the import documents, the examiner found that the duties and taxes to be paid is 20,000 pesos. Clearly, there is a 100% discrepancy since the duties and taxes as found is double the amount of what is declared. What is the effect of this? As I mentioned earlier, aside from the seizure of the shipment, it will be subject to the imposition of 500% surcharge. Moving forward, the following are the instances where the imposition of any surcharge may not be applied. 1. When the discrepancy between the duty to be paid as legally determined upon assessment and what is declared is less than 10%. For example, the duties and taxes declared is 950 pesos, but the duties and taxes as found is 1,000 pesos. In this instance, there is only a 5% discrepancy. Thus, the imposition of surcharge will not be applied. Next, when the declared tariff heading is rejected in a formal customs dispute settlement process involving difficult or highly technical question of tariff classification, or when the tariff classification declaration relied on an official government ruling. To discuss, a difficult or highly technical question of tariff classification occurs when the goods are classifiable under more than one ASEAN Harmonized Tariff Nomenclature Chapter or AHTN chapter, heading or subheading, or the product description is not specifically provided for in the AHTN, subheading or heading, and it will need the ruling of the Tariff Commission for its determination and resolution. Thus, although there is an erroneous declaration of tariff heading as ruled by the Tariff Commission, no surcharge shall be imposed since it went through a formal customs dispute settlement process. Next, when the declared value is rejected as a result of an official ruling or decision under the customs dispute settlement process involving difficult or highly technical question relating to applications of customs valuation rules. So to recapitulate, the first instance was technical question on classification, and this one involves difficult or highly technical question on valuation. And lastly, when the misdeclaration, misclassification, or undervaluation was subjected to timely amendment and was corrected prior to final assessment or examination of the goods pursuant to Section 408 of the CMTA. To briefly summarize, the imposition of fine in the amount of 5,000 pesos per error shall be made if the error committed is merely clerical or inadvertent. On the other hand, the 250% surcharge shall be applied when the error committed constitutes misdeclaration, misclassification, or undervaluation, and there is a resulting discrepancy in duty and tax to be paid between what is legally determined upon assessment and what is declared by 10% or more. And lastly, the 500% surcharge will be applied when the misdeclaration, misclassification, or undervaluation is intentional or fraudulent. In closing, Customs Administrative Order Number 1-2020 strengthens the commitment of the Bureau of Customs to ensure that all submitted documents reflect accurate data in order to arrive at the correct duties and taxes due to the government and to timely process the release of the shipments. Thank you very much.